Donald Trump and those he's appointed to education offices have some very controversial opinions when it comes to what our nation needs and what direction to go in terms of funding and the structure of our education
The
system.
bottom line is we believe that parents are the best equipped to make choices for their children's schooling and education decisions, and too many children today are trapped in schools that don't work for them.
Betsy DeVos, our current Secretary of Education, has made some hardline arguments for the use and expansion of voucher programs started in the G.W. Bush era. Under these programs, private and charter schools would be able to receive funding from federal and state governments, thus reducing funding for our public school system. But this support of school choice could have some very negative impacts on an already struggling American school system. Now, America's education system has never been known on the international scene for its achievements, ranking 38th on average out of 71 worldwide nations studied in a 2015 study of reading, science, and mathematics. But another major area of concern is the diversity of our classrooms. With a large trend towards more racially segregated schools in the U.S. in recent decades, it is important to look into this area and understand what's going on. First, let's take a look back. In the late 1950s and 60s civil rights movement, major strides were taken to desegregate our public school system. This is considered one of the most successful parts of the movement. The system of segregated schools, particularly in the South, were uprooted by the landmark case Brown versus Board of Education. It overruled the previous judicial precedent of the Plessy v. Ferguson case's separate but equal decision, and mandated the integration of the public school system to ensure equal education opportunities. However, as clear as this may seem, it was followed by a long series of legislation and court battles that have exploited the laws preventing school segregation. Initially, segregation in public schools was essentially allowed in some districts because of the type of segregation they were experiencing. De jure segregation, or separation by law, was banned. However, de facto segregation, or segregation by choice or other means, was not. This meant that in many cases, segregation continued decades after the Brown v. Board case was decided. The next contender to solve this issue was the case of Greenville County School Board. In this 1968 case, public schools were banned from relying on freedom of choice plans, which legally allowed students to decide their place of education for integration of public schools. And while this was a step in the right direction, it wasn't nearly the end. In 1973, the case of Keys v. School District No. 1 determined that another form of segregation, which integrated all minorities, particularly Latinos and African Americans in this case, into separate districts from white schools. This diversified the districts and technically met the definitions of integration, but failed to hold up when challenged in court. The court declared that the Denver School District was in violation by practicing de jure segregation and banned the use of this form of loophole segregation. However, not all cases were as successful as these. In the 1974 case of Mulleneberg versus Bradley, the Supreme Court found that mandated busing to integrate schools suffering from de facto or choice segregation was unconstitutional, and that integration could only be legally enforced by the courts in districts that displayed de jure segregation. This was made worse in the 1992 case Freeman versus Pitts, where 6 school districts were found to be illegally segregated. They were mandated to be integrated and monitored by the courts. However, once 4 of the districts were considered accounted for, they argued they should no longer be monitored. The Supreme Court agreed and stated that so long as the district was compliant, a court did not need to maintain control of a school district's desegregation efforts. There are 2 problems with this. 1, a district may be compliant with its lack of desegregation efforts and fail to uphold them once they are released from being monitored. And 2, many already poor districts struggle to find the immense funding for a legal battle arguing their districts should be integrated. These already financially poor and struggling districts would have to not only find the funding to fight a legal battle, but be willing to chance a court loss, as seen in the Mulleneberg versus Bradley case, and have to pay their opponents' legal fees as well. This discourages districts leaning towards racial disparities from acting on the inequalities that they face. Another area of discussion as far as modern education integration is concerned is how school districts receive their funding. In the case of Serrano versus Priest, a Los Angeles public school district argued against the California school finance system, arguing that it relied too heavily on local property tax and disadvantaged the students in districts with lower income who lived in poorer districts. It is here where we need to take a step back and understand how this connects to racial education equality. According to the Kaiser Family Foundation, there are more than 2 times as many minorities below the poverty line living in America in 2017 than white Americans also living below the poverty line. Why this is would require its own video, but it is a necessary statistic to understand how taxation levels affect school funding. Therefore, minorities who cluster or live in higher minority concentrations, such as inner cities, can face worsening education systems. There have been additional attempts to solve this problem, including the Robinson versus Cahill case of 1973, which similarly argued against property tax-funded education systems in New Jersey. Lastly, in the case Rose versus Council for Better Education, the state finance system of Kentucky was challenged and determined to be unequal. These cases all heavily relied on the 14th Amendment's Equal Protection Clause, which states that our governing body must treat an individual in the same manner as others in similar conditions. In other words, the government cannot discriminate against individuals. However, as 4th Supreme Court Chief Justice John Marshall said best, the power to tax is the power to destroy. In the case of San Antonio versus Rodriguez, a group of primarily Latino students in a Texas school district argued that the school finance system also relied heavily on property taxes for funding disadvantaged districts. But in the Supreme Court's decision, they decided that the Equal Protection Clause was not violated after deciding the system did not intentionally or substantially discriminate. This new precedent puts a hole in using the 14th Amendment to prevent this issue, and is further emphasized in the case of Levittown versus Nyquist, which again found in New York that property tax-funded districts that were suffering from less funding should not be supported by the courts. This is made even worse when advantaged students with more wealth are able to pick their school of choice. This allows for wealthy white students to avoid school districts with larger minority race populations by opting for alternative school methods. Here is where we turn back to today's modern school system, which is suffering from these court inconsistencies. Furthering this issue and making more inequalities for schools is Betsy DeVos's proposed expansion of voucher programs. These would allow government funding for education to be spent elsewhere in private schools and charter schools, which racial minorities statistically cannot afford. It is here where we come to a crossroads. Much progress has been made since that Brown v. Board case, ensuring equal and integrated education for all. But with so much line crossing, it can be hard to see what's real and what's not. Either way, the stats are trending negatively, and it's up to us to ensure these disparities are ended for good.
We have to do something different.